Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be essential terms for your rental agreement. Don't get sued. All this while I'm vacationing off the coast of France. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m., except for me right now. It's midnight on the 27th of July because I happen to be floating on some ship from between Spain and France on the Regent Splendor, and of course another summer trip that I got dragged on. This time we took all the family with us, all three kids, the grandchildren, and wives, and even extended girlfriends. So we're here, and I'm having actually a really good time on this trip. But I didn't want to not have a show, and so I am opening this up, even though I am on vacation. So I did want to talk today about the format of the show. By the way, if you were listening live, the name of the song was America by Simon and Garfunkel. Simon wrote that song in 1966, and it actually was a true story about himself and his girlfriend, Kathy, who did a bus trip around the country, and I always loved that song. In terms of our show format, what happens, of course, we know is that I have an opening topic. And then after the opening topic, those people that are in the Zoom meeting room, if you'll please raise your hands. And I do see many people have done so already electronically. I will call on you in the order that, in fact, you did raise your hand. If you are watching on YouTube, I would ask you, please, if you could hit that like button and subscribe to the channel because it does help me very much. Also, if you are in YouTube, please leave your comments if you have a question or something you would like to suggest, and I will get to that in the next few days or so your questions can also be answered. So, what is the topic of the day? And that topic is essential terms for your lease agreement to prevent yourself from being sued. My friends, it is a very litigious world that we live in. And you guys, if you're owning income properties, specifically residential income property, you really have to understand what's going on because there's marauding a bunch of attorneys that are out there to just bring lawsuits against you. And part of the preliminary things is that you have to understand the laws dealing with both local and state laws. So if you have local rent control laws for your jurisdiction, such as Los Angeles or Santa Monica, then you need to know what those local rules are. If you don't have local rules, then you need to know what your state rules are. And that, again, you need to do some research, go on a website. You don't have to know the laws for every jurisdiction. You just have to know the laws for your jurisdiction. Okay. Also, when you're dealing with tenants, you have to exercise good judgment. Don't try to put yourself in a situation where they're going to allege that you've done something wrong. Try to avoid conflicts at all costs, because we all know that when tenants get sued, it's not a big deal because they got no money. But we know that landlords are the ones with the money, and it is a big deal when we get sued. So try to use your judgment and try to be in a situation with your tenant where you're not walking into a trap. So you want to avoid these conflicts. And another way, of course, you can do so is by doing regular inspections of your property and also doing proper maintenance of your property. If something needs to get fixed, fix it. Don't wait till tomorrow. Call that plumber, okay? Call that electrician, call that person today. You're going to have to call him anyway. And this is just going to create a situation where someone's going to allege that, in fact, that you were not acting like a proper landlord. And then you're going to open yourself up to a lawsuit. And the next issue with regard to tenants is that pull out your insurance policy. And I know it's almost impossible to get insurance these days, especially if you're in the moronic state of California, based on the poor judgment of our legislators and our wonderful governor. But pull out your policy and go over it with your agent to make sure that you're covered for as much as that you can be covered for. And that is including discrimination, also dealing with issues dealing with habitability, because these are the ones that literally are going to keep you up at night when you have to hire an attorney to defend yourself, whether you've done nothing wrong or whether you weren't really on top of your game and allowed that tenant to file that lawsuit. And again, a tenant doesn't need much to file a lawsuit, even if you've done everything proper. So you want to make it in a situation where you've done your proper maintenance, you've got your proper insurance, and you used good judgment in terms of maintaining your property. But then, as we get to the topic of the day, what is your last line of defense? And your last line of defense is having a great rental agreement. If you have a great rental agreement, that will save you, I cannot imagine. Now, I could actually stop this seminar right now by just saying, hey, you want a great rental agreement? Go to my website, evict123.com, and click on the free form section and just use my rental agreement, because quite frankly, my rental agreement is not just the standard rental agreement like California Apartment Association, all those others. I've actually put in so much more into my agreement that will save you in many, many circumstances. And even if you don't want to change your rental agreement for mine, then just add the phrases that we're going to talk about today, which will deal with keeping you ahead of the game in terms of getting sued. Those paragraphs that you do need to have in your rental agreement, which will save you. So what is those? Well, first of all, if you have existing tenants, can you get them to sign a new rental agreement? And the answer is no, you can't, because most tenants are under rent control, and you can't force a tenant to sign a rental agreement once they're already in possession. There's no way to kind of take their arm and hand and stick it to a rental agreement and force them to sign it. You're kind of stuck with what you got. Now, you can try to use a little psychology. For example, you could tell them that, and we'll just take Los Angeles as an example. Hey, you know what? If you're agreeing to sign a rental agreement, I will forego a rent increase, which this year is 3% for Los Angeles, for 1 year. That might be incentive. By the way, it's 8% if you're under statewide rent control. But that might be incentive for that existing tenant to sign a rental agreement. Again, we're just merely trying to protect ourselves. So if you have a situation where you have an existing tenant, we know that you can't force them to sign it. So maybe you need to incentivize them to do so. By the way, if your property is not under any rent control and you have an existing tenant in possession, then what you can do in that situation is just say, hey, if you don't want to sign this, then I'm just going to serve you with a notice to terminate the tenancy. That would be a 60-day notice if the tenant has lived there longer than 1 year. So that would be a way of forcing a tenant to sign a rental agreement, assuming you're not subject to any rent control, which, quite frankly, is very rare in the state of California, since they do have statewide rent control. Okay, when you have a new tenant coming in, of course, you're going to have them sign a rental agreement. And again, my rental agreement is on that website, evict123.com. It's free. It's in the free form section. Make sure that if you're handing your tenant a rental agreement to sign, make sure that what you do is not sign it. You are the landlord, my friends, and that means you are the lord of the land. You do not sign that rental agreement first. You let your tenants and every adult who's moving into your property needs to sign that rental agreement first. Then, once it's signed and you have their signatures, you then sign another copy for them and give them their copy of it. But don't make a rookie mistake where you sign a rental agreement, you give it to your tenants, and they go, oh, I want my attorney to look at it. And then, of course, he's off with your rental agreement, and then you're kind of in limbo, because if you try to rent the premises to somebody else, he's going to come back and say, hey, I have your signature and you haven't rented it to me. So what that means is that you are going to be then renting it to two people. And again, you're going to get sued with that. So make sure, again, when you give them a rental agreement, you are the last person to sign it. The next thing is my rental agreement allows you to do either a fixed term lease or month to month. And lately I have been suggesting, and I know everybody wants to do a 1 year lease based on the current state of affairs, based on statewide rent control, based on local rent control. For example, the city of Los Angeles, which has just cause ordinance, I recommend just doing a month-to-month rental agreement. And I have said in numerous broadcasts, if you want to exclude Section 8 tenants by just offering month-to-month to every single applicant for your building, not just Section 8, it will be a way of preventing Section 8 tenants, because Section 8 will not allow you to lease to a tenant unless you're offering them a 1 year lease. So on that basis, when you are preparing your rental agreement, at this point in time, I recommend just doing a month-to-month tenancy. Okay, once you have that rental agreement, you want to make sure that when you're filling it out, that you want to list not just the names of the tenants, and that is every adult is going to be named a tenant and is going to sign that rental agreement, but you also want to make sure that you list all occupants as well. So anybody under the age of 18, like children, you want to list their names, you want to list their birth dates, and those are going to go right in your rental agreement. That's going to prevent what they call the revolving door, where people are coming in and out and you have no control over that. So you're going to list not only the number of occupants, but you're also going to list the names of the tenants who are all going to sign the rental agreement. Those are all the adults who are moving into your unit, but also those people, also, for example, children under the age of 18, you're going to list their names in the space called occupants, and with their names and their birth dates. Okay, we also want to go to an issue dealing with, as in my rental agreement, the right to enter the property. Now, we do know that under the general rules of Civil Code Section 1954, you have the right to enter the property to make necessary or agreed repairs, to show the property to a prospective tenant, to show it to a prospective mortgagee or an appraiser, to show it to a prospective purchaser of your unit. But there's an issue of whether you can just enter a dwelling just for periodic inspections. I believe that under Civil Code 1954 you can, but there has been some debate whether in fact that's operable for you to actually check a unit, make just an inspection of your unit at least once a year or twice a year. So in my rental agreement, it specifically states that I can go in for periodic inspections. So this way you're expanding Civil Code Section 1954 so that you have the right to go in there. Maybe you want to check smoke detectors. Maybe you want to go in there and change the filters on an air conditioner. Or maybe you just want to see if they've really built that methamphetamine lab in the living room. So again, a good phrase is to spell out exactly when you can inspect the unit, which will expand Civil Code Section 1954. Okay, the next thing you want to do is you want to make sure that there's a phrase in your rental agreement that talks about temporary relocation. Temporary relocation. Many times, for example, you'll have termites and you have to tent the building and the tenant has to leave. Or sometimes there's a flood through no fault of the tenant. And then the tenant is forced to vacate the unit. And of course, these tenants are going to want to be compensated. Maybe they want the Ritz-Carlton, maybe they want the Four Seasons, and they want you to pay for that. Well, you want to have a phrase in your rental agreement, as such as is in mine, that specifically states that if you have to temporarily relocate, then the only thing we're doing for you as landlords, and you're agreeing to this because you signed that rental agreement, is that you are only going to be compensated by a per diem rate based on the value of your unit. So for example, if your unit is going for $1,000 a month, the most I'm going to do is give you $33.33 per day for every day that you couldn't use the unit. And that is a very valuable term because you always have these situations where a tenant has to vacate the unit and he's looking for compensation. And of course, the landlords are always calling my office and asking me, well, what do I have to give them? Well, generally under California law, you don't have to give them anything, but you want to have that actually spelled out in your rental agreement. You also want to have in your rental agreement that the tenant, and again, that's contained in mine, has to maintain renter's insurance. That he has to maintain renter's insurance. And what does that paragraph deal with? Well, it deals with that if his personal property is damaged, that his sole way of being compensated is based on his renter's insurance policy. Now, you can't actually force a tenant or evict a tenant based on the fact that he doesn't have renter's insurance. However, by having that phrase in there, he can't sue you because he was supposed to have that renter's insurance. And that's exactly what it says. He agrees to be indemnified by his insurance and that he cannot sue the landlord. And that also goes to the fact that the renter's insurance will also cover if he has to temporarily relocate, that his renter's insurance will cover that. So we have it in two places as opposed to temporary relocation. And the second one is based on the fact that he has to have renter's insurance. And again, if he doesn't have renter's insurance, you don't care. Because what you want to do is that if you're getting sued by him, you can point to that provision in the contract which states that, hey, if your personal property was damaged, you had to have your own insurance. I'm sorry that you didn't, but you had to have your own insurance. And also, if you have to temporarily relocate, then your insurance policy was there to cover you. And all I'm going to do is give you a per diem rate when you couldn't occupy the property. Okay, let's move on now to, and I'm going to share my screen, to another paragraph that's in my rental agreement, and that is dealing with abandoned personal property. And I'm going to show you my rental agreement. So what is that? This is paragraph 29 of my rental agreement. And if we ever had a situation where a tenant vacated but left a bunch of stuff behind, and now you're sitting in a situation where, oh my God, what do I have to do with this? Well, there's technically a form, another form on my website dealing with abandoned personal property. And you'd have to fill that form out, mail it to the last known address, wait 18 days, and assuming the stuff was worth less than $700, then you could toss it away. But if it's worth more than $700, then you're going to have to hold a public auction. But you see, I have a phrase in my rental agreement which makes it so much easier, and that states, hey, if you vacate the premises, all personal property left behind shall be abandoned, and the landlord may dispose of said items in any manner that the landlord chooses. No notice is required. And that's a very valuable provision in your rental agreement, so you just don't have to deal with their garbage, like, does he really want this this mattress filled with bed bugs or not? You can immediately throw this stuff out. Another term in my rental agreement deals with subrenting, where you can't subrent your property. Now, this comes up a lot of times with regard to Airbnb, where these people who are under rent control paying a little bit of rent, and yet they're subrenting your unit on Airbnb, and they're actually making more money on the unit than you're making on the unit. But here's the problem. Even if your rental agreement says no subrenting, the problem with that is that if you determine that they are, how do you prove it? Well, if the person who's moving into the property with his bags for the weekend says, oh, yeah, I rented it on Airbnb, but that person's going to be gone. So if you serve your tenant with a notice to perform or quit to stop subrenting, then those people are going to be gone in 3 days, and there's no way to prove that they were subrenting because you'd actually have to have them come to court with you whenever that case came to court. And how long is that going to take? So I have another phrase in my rental agreement that says tenant agrees not to assign or sublet the premises, and here's the kicker, or to advertise to do so without first obtaining the written permission of the landlord. So in this case, if you determine that in fact your tenant was going on Airbnb, you don't have to have these people come to court to say, yes, I rented it from him. All you have to do is find the advertisement, the Airbnb advertisement, which isn't really that difficult to do. And what you're going to do is, in that situation, you're going to serve your tenant with a notice to perform or quit, another notice I might add that's on my website. And if in fact you then see after the third day that his advertisements are still up, then what you're going to do is you're going to then merely take a picture of that. And now you have perfect proof that in fact he was in violation of his contract. And in my contract, it's paragraph number 6. Let's move on to parking. In parking, you want to make sure that when you do offer parking, and my agreement says that you can offer parking or not, but you do want to list a specific space or location where his parking has to be. You don't want him parking all over the property. But a lot of times what happens is that these tenants have a parking space, and what they do is they put in an old couch or a dresser or some other garbage that's listed, and it makes your place look like garbage. So in my rental agreement, it specifically states, hey, if I give you a parking space, then that's only for the parking of a passenger automobile. It also states that that passenger automobile must be operational. It also states that it has to be registered, properly registered. So if you have some old car or junker that's in the spot, you actually have some power now on the basis that, yes, you're parking that junker in your assigned spot, but you know what? It's non-operational and it's not registered currently. So that would be grounds that you could get rid of that person in terms of forcing him to get rid of the car or at least park it off your property. Or if he refuses to do so, that's a wonderful ground for eviction. Let's move on now. I'm going to stop sharing my screen to alterations of the property. That's another paragraph that I have there in my rental agreement where you're not allowed to alter the premises, putting up another wall or installing a washer and dryer or putting an air conditioner or even putting Ring doorbells outside on your property. But it also goes further. It states that you can't put placards in the window, signs in the window. And I've had it where tenants, disgruntled tenants, will put a sign in the window that says, this is a bad landlord, don't rent from him. And how would you, as a prospective tenant, if you saw that placard in the window, that would dissuade you from actually ever renting in that unit. So you want to have a paragraph that not only talks about alterations of the property, you also want to say no placards. Now, there is a California law that says within 90 days of an election, you can put up a political sign. But other than that, you don't want to have any others. You don't want to see a Jimi Hendrix sign. I don't even know who that is. No, actually, I do. In the window. So you want to make sure that not only there's no alterations, but that there's no placards in there. Also, you want to have a phrase in your contract that says you can't store personal property in the common areas. You can't believe how your place will look like a slum when these tenants are sticking old refrigerators or televisions or couches or their children's toys or their barbecues. You want to make sure that, hey, you cannot store any personal property in view of anybody in any common areas. All that stuff has to be into your rental agreement. Now, I'm going to move on now and I'm going to show you this, which is another interesting thing that I have in my rental agreement. And that is here, arbitration. So what's that all about? Well, you got these tenants and, they're slipping down the stairs and they're just pretending that they've got hurt, all this other garbage, and then they're bringing forth these lawsuits. So I have a phrase in my rental agreement that says that it's mandatory that if you're going to sue me, we first have to go to arbitration. And I've actually made it, this is only a part of that paragraph 27. I've made it where it's really difficult to do so, where they're going to have to go to the American Arbitration Awards, and that's going to create a it's much more difficult. Also, it's cheaper for you if you do have to hire an attorney to go forward with that. So again, that is a wonderful phrase. Now that's not for any kind of like lawsuit for unlawful detainer. It's only for any dispute where they're suing you for personal injury. Okay. And now we're going to move on to the last one, which is that again, that dealing with paragraphs in my rental agreement that uh, landlords are have the tenant has to inform the landlord in writing if he needs any repairs to the unit unless it's of an emergency situation. If it is an emergency situation, then of course the tenant can tell you immediately. But otherwise, you want to make sure that all repair requests are in writing. Now, the reason why you want that, and I've talked about this before, is that you want to make sure that if the tenant is defending in an unlawful detainer and he's claiming all these things were wrong with the premises and that's the reason why he withheld the rent, well, you want to make sure that your rental agreement says, hey, you have to notify me in writing. And if you didn't, then you can't claim now in an unlawful detainer action that that's the reason why you withheld the rent. I want to see the proof that you notified me. Also, all these attorneys are now bringing forth lawsuits based on habitability, that the landlord is a slumlord and didn't fix anything. Again, your position is, hey, I want to see in writing when you asked me to fix something, because I certainly would have. But this paragraph goes on even further. A lot of times tenants don't tell the landlord. And what they do is they call up, for example, the Los Angeles Housing Department or Building and Safety, and they come out and there is something legitimately wrong with the premises. But again, you're not a psychic landlord. They never told you about this. So now you get something called an order to comply from Building and Safety, and now you have to do it. But what you also get from that is a bill from Building and Safety for that inspection fee, and that can be for anywhere from $200 to over $300. So my paragraph goes on to state that if you fail to notify me and you contact any Building and Safety first without first notifying me, what that means is that you are going to be responsible to pay that inspection fee. That's just a wonderful term that you can have in your rental agreement. So my friends, what we have here are the essential terms that you should have in your rental agreement to avoid lawsuits. And again, my rental agreement, which of course contains all of this, is located on my website at evict123.com, and that's in the free form section. And now that we have opened our topic, we are now going to open it up to questions and answers for those people that are in the Zoom room. And you know the usual rules, and that is that this is only for informational purposes only and does not qualify as legal advice. If you do want to talk to me and you're in the Zoom room, please electronically raise your hand. If you are a client of mine, this forum is only for general questions only. Please save those questions and call my office on Monday. And last but not least, if you are in the Zoom room and you are talking to me, please leave your camera on because it does make it much more enjoyable for the audience. And do not forget, you people who are watching me on YouTube, please hit that like button and subscribe to my channel. And if you do want your questions answered or you have a comment to make, please leave it in the comments and I promise you I will get to it. And with that, we're now going to open it up to questions and answers. And the first person is iPhone. I'm going to ask you to unmute yourself.
Hi, Dennis. I'm hoping that you're enjoying your vacation.
Oh, I certainly am. I'm getting dragged all over the place, but I am having a good time.
Yes, I have two questions. Well, I kind of went over these questions with you a few weeks ago, and one's in regards to the Section 8 tenant that I have to give a 3-day notice to pay or a 30-day to quit to all of my residents. I have this one particular resident that's really fighting me on this case, and he has produced some document from one of the other tenants that shows that they are a Section 8 tenant. What should I do with this case? Should I just start over at this point? Because I guess I'm gonna lose the case, right? Because I only
Oh, I
gave them a
see what you're
three.
saying. Is this tenant a Section 8 tenant?
Not the tenant that I'm currently fighting with, but
O- Okay, so I
trying to
think
fix.
what you're saying is that there's some ridiculous federal law that states that if you're serving a notice to pay rent or quit on a tenant who's not even a Section 8 tenant, but you have a
Yeah.
Section 8 tenant in the building, then the correct notice, believe it or not, is a notice to pay rent, a 3-day notice to pay rent or 30-day notice to quit. And if you didn't serve that notice, then technically you are in violation of federal law. Is that what your situation is, sir?
Yes, it is, and they have gotten. I guess they are friends with the tenant that's on Section 8, and that tenant that's on Section 8 have provided proof that they currently get Section 8 through my building.
Well,
So
my
it's
friend,
almost like,
I would just dismiss the case and start it over again at that point.
okay, and then this other case I have where we I my process server served the something complaint by substitute servers, I think that's what they call it. But the tenant is saying that they never got the mail copy. So would the proof of service be enough that the process
Okay, the
server
law says that
filled
if
out?
you're serving a notice to pay rent or quit, for example, the law states that if the
Mhm.
tenant is not home, then you're allowed to post one and mail one. The law does not state that the tenant has to receive it. The law just states that you have to post one on the door and mail it. So the fact that the process server can testify that in fact the notice was posted and the notice was mailed, that's all you need. The fact that you didn't get, that's your problem. It's not my problem. So you're
Yeah, 'cause I
okay
thought
on
it was
that
a
one.
post office issue, I guess. Hey, that's all I needed. I hope you enjoy your rest of your vacation. Thank you so
Thank you
much.
very much. Got another week to go. Thank you very much. And we are moving on to a person by the name of Jackie. I'm going to ask you to unmute yourself.
Hey, Dennis. Thank you for all the support you give us landlords. I really appreciate it. Um, I wanted to ask you a couple of questions about the agreement provisions, and then I have a question about a strategy that I'm trying to pursue with moving back into my rental. Um, the first question relates to the provision about requiring renter's insurance. In my old agreement, I had a provision that said that the tenant was required to add me an additional insured and to carry liability up to 500,000. And I don't know if that's illegal and or advisable if there's because I noticed your provision talks about only the landlord, the tenant is indemnified by that provision.
Well, I don't think you need to be added as an additional insured because that's only for the insurance. Renters insurance only provides renters with insurance for their personal property or where they have to temporarily relocate. So you don't need to be compensated for that. Any damage to your property would be compensated by your own insurance policy, like if there was a fire or a flood, etc. So and obviously, the tenant's renter's insurance isn't going to compensate you for any damage to your real property. But the reason why you want to have that is because you don't want the tenant coming after you if his personal property is damaged, or in fact, as he wants to be compensated for any relocation, some temporary relocation. So as long as that paragraph's in there, you're protected. As to your own property, get your own insurance.
I totally agree with you, but my understanding is that the renter's insurance also has a component for example, one of their invitees slips and falls on the property, and now they're coming in for personal injury, and that's what the liability protection would help out with.
Yeah,
Also,
renter's insurance is not going to cover that. There's no renter's insurance policy that's going to cover if the tenant slips and falls on the property that they're going to cover it. That's not what renter's insurance is. So that would
okay.
be your liability insurance. You just don't want to be responsible for the tenant's personal property or in case he has to temporarily relocate. And that's about as far as that's going to go.
Okay, so my second question is, I read in the handout that the city has for the JCO that the notice that you have to put on the property also has to be included in the rental agreement, which sounds a little odd to me. I haven't seen anything like that that applies to the LA City RSO. So do
I
you
haven't
have to
seen
include?
that for the just cause
So do
I
you
haven't
have to
seen
include?
that for the just cause ordinance. Those properties that are not subject to the rent stabilization ordinance for the city of Los Angeles, every other property, including a single family home, is subject to that. That notice just needs to be posted on the property, is my understanding of the law. So just post one on the property. And it's interesting when we serve notices. And by the way, that notice has to be posted on all residential properties, RSO or non-RSO properties or JCO properties, just cause ordinance. But when we serve, let's say, for example, a notice to pay, rent, or quit, I'm going to serve those notices as well. So, but again, I think it just needs to be posted on the property. Anyway, thank you very much. We are going to move on to Rosanna. I'm going to ask you to unmute yourself.
Okay,
Hi there.
can you hear me now? Yes,
I
hello.
can.
Okay, I would like to ask a question regarding making an objection to a jury trial request when a tenant has filed an answer in an unlawful detainer. I know that
And what do you
it's
mean by an
supposed to be
objection?
timely. Hmm?
What do you mean by an objection?
For us to make an objection, the
Well, there
landlords
is no such
or their
thing as
attorney.
objection to a jury trial request. Under the laws for this California, it's constitutional that any litigant, including a landlord or a tenant, has the right to a jury trial. It's not a matter for a judge to decide. Technically, they have to request a jury trial 5 days before the actual trial date, and they have to pay the filing fee unless they have a waiver. But there's no way to avoid a jury trial if one party asks for it.
Oh, right. I understand the constitutional basis. True, I'm an attorney myself. I'm just understanding that there needs to be procedural guidelines they need to follow. And does it just have to be on their answer, or do they also, after posting this fee, have to file a counter request, or what's called an ad issue memorandum, requesting the jury trial? Do they have
No,
to do
they
it
can
like
either put
three
it, they can
times?
either request the jury trial within the confines of their answer, or they can do it as a separate document that says demand for jury. Technically, they do have to post fees, which is $150, and they have to do all that 5 days prior. Most tenants ask for a fee waiver, so they don't have to post a fee, but if it's contained in their answer or in a separate document that says demand for jury, they get it. And even if the tenant doesn't do that, and let's pretend within the 5 day period, these judges have discretion and they just exercise it all the time to say, okay, you didn't do it correctly, but I'm still going to give you the right to a jury trial.
Okay, so then we have to go on and set it for a conference and all of that. Because I've really done a jury trial, but I've seen them use it for, I guess, leverage in negotiating a settlement if they
I would
want.
say in 95% it's for leverage only, that they're not prepared to do a jury trial. But our methodology of dealing with that is that we will prepare all of our jury documents, we'll exchange them, even though the tenant doesn't. We'll send out discovery and which of course a lot of times they wouldn't even answer the discovery, so we can file motions to compel. But this way, when we get to court on the first day, we can announce ready, our jury docs have been filed with the court. And usually I would say about 95% of the cases, we get the tenant to settle the case where they move because we're ready to proceed forward with it. I can tell you of those cases that actually go to jury, we've won, actually, I have a count here. We've won 19 of the last jury trials that actually went to jury. So our firm is pretty successful in going forward with jury trials, but the name of the game, as you can imagine, is to try to avoid a jury trial and just get the tenant to vacate the premises as opposed to going through the expense of a jury trial.
Okay, well, yeah, it just makes me wonder why a tenant who can't afford to pay their rent is paying all these legal fees to prepare a jury and discovery and everything
Yeah,
else needs to be
pay all
done.
these legal fees. To who? they're getting free attorneys. The city of Los Angeles, which is $1 billion deficit, has made it where you get free attorneys. They just started that program. The state has that program. LA County has that program. They pay zero. This is just a boondoggle to protect tenants, and basically it's just to destroy our property rights. So they're not paying anything, zero, less than
Oh,
zero.
they are.
And
Okay.
of course, when they do lose their case and they do get evicted, generally the judgment is sealed. And you know what, Rosanna, they're moving on to the next landlord and doing the same thing. And they can live year to year to year for free. And nobody gives a damn if they happen to be any kind of a legislator or our wonderful governor. Anyway, thank you very much. We are moving on to Sosi. I'm going to ask you to unmute yourself. Say hello,
Yeah.
sir.
Good afternoon, Dennis. This is Associates with me. This is Hago. Thank you for all your help. Quick question. I have a tenant that had not paid rent for 2 months. They owed back late fees. They just paid 1 month's rent that she owes me a month, and next month is coming in. Could I deduct what she paid from the late fees first and then the rent?
Okay, I don't think I'm following the question. The tenant owes you 2 months rent, and then they just paid 1 month, correct?
Yes. And she
And
also
what is
owes $1,800 in late fees that accumulated over the last 1 year.
okay?
Paid
Good,
the
good
late-
question. You can't. It's the debtor, or in this case, the tenant who decides what he's paying for. You can't apply the money that he gave you and say, well, I'm going to apply it towards late charges. No, those fees go to the rent if that's what the debtor or the tenant is applying it for. However, you can bring forth an eviction based on failure to pay late charges. It would be considered a notice to perform or quit. But if the tenant is saying, hey, I'm paying this and I'm paying this for the July's rent, then you can't apply that towards late fees.
Great. Thank you, Dennis.
Is there a place in the rental agreement that we can add the late fee be collected prior to the rent?
Not really. What you need to do is, if the tenant doesn't pay you the late fees, you can bring forth an eviction and just serve a notice to perform or quit for the late charges that he owes.
Okay, thank you.
Thank you. Have a nice
All right. Good question. We're moving on to Eric Chavez. I'm going to ask you to unmute yourself.
Dennis, you got me.
Hey.
Did I keep going?
I got Harold. What happened to Eric? All right, we'll talk to you. I'll see if I can find Eric.
I'm glad you're having fun. Okay, here I had a notice to my tenant that I gave in May for June 1st to raise the rent. At the time, the consensus was if your cost of Hawkins doesn't matter, you can charge whatever. So basically, I'm 9% higher. And then it came like, oh, you can't do that. It'd be 8. So my question is, if Newsom said it has to be 8, can you still include 1% for the utilities? No, you're stuck at 8.
Okay, 8% would only be if your property is subject to statewide rent control, and we've gone over this, that your property is a single family residence. So you can
Right.
charge whatever you want. So you can certainly go above 8%.
But I thought there was like a freeze for everybody, including Costa Hawkins.
There is, well, I think Costa Hawkins is supreme versus the quote state of emergency because of the fires that occurred in LA County. And
Okay.
that's going to be over, we hope, at the end of October. So right now I would do an 8% rent, a 10% rent increase. And then, because then you're within that statute dealing with rent gouging. And then once the end of October rolls around, then you can raise the rent to whatever you like. Anyway, thank you very much. We are going to move on. I'm going to see Eric. I don't see whether you've raised your hand. Let me see if I can get back to you. I'm going to ask Eric to unmute yourself. Your hand didn't get raised. If you want to talk to me, I'll give you a chance. No.
Hey, Bruce, Dennis, it went to me again. It went to Harold again, the second time, 2 in a row.
Okay, well, mute yourself, Howard. We're going to move on. Okay. We're going to pick now Jonathan Kennedy. I'm going to ask you to unmute yourself.
Dennis, I've been doing some research. A tenant asked me to be, he asked me to re-rent his unit. He's a couple of months into a 1-year lease. Um, and I'm running into some things that kind of surprised me. I thought I could just basically say, okay, fine, I'll re-rent I'll find another tenant, and then as soon as that rent starts, you'll be out of your lease. But what I'm finding is sources that say that if I voluntarily take the keys from the tenant, that I'm surrendering and
What do you mean
not
you're voluntarily taking the keys? Your tenant is handing you, he's telling you he's gone and he's giving you the keys. You didn't go over there
I
and
know
grab it out of his pocket, did you?
that's what mystifies me is that I'm seeing sources that say if I take the keys, then I'm surrendering the lease and I can't and I have no
Well,
right to collect rent anymore.
okay, so wherever those sources are, I would take them and throw into the closest garbage can because it makes no sense. Your tenant
Okay,
is
good.
telling you that he's vacating, okay, and you're telling him, okay, then I'm going to use my best efforts to mitigate your losses by trying to rent it out to the first person that I can. And in that
Exactly.
situation, until you do rent it out, he is responsible. By the way, when he does vacate the unit, you have 21 days to send him a security deposit itemization, and you will list on that security deposit itemization that you owe me not only this month's rent, but for the next 10 months of the lease. Okay, so whatever those
Okay,
sources are, my good friend, lose them.
and then
Uh, wait, I think I hit the button. Wait, unmute yourself again. Go ahead with your other
the other
question.
question the other question that arises from this situation is, am I trying to rent the unit for another year at a rent that's closer to market, or am I limited to re-renting it for the remainder of his term at his rent?
Okay, you can re-rent it for another 1 year period, which would be beyond the term of his lease, but technically you have to rent it for the same price. If you try to rent it for a higher amount, then technically he is not responsible at that point, which is a little
Because I'm
quirk in
not
the law.
mitigating damages. Yeah,
Yeah, so
because
you
I'm
have to
not
rent it for the
attempting
same
to mitigate.
amount.
Okay.
Anyway, I'm moving
Oh,
on. Thank you very much. We are moving on to Julia Jordan. How are you? Julia, are you
Hi,
there? Yes.
Dennis. I'm good. How are you?
I am good. I'm floating in, I don't even know where I am, but someplace between Spain and I'll land up tomorrow morning in France, someplace.
Well, good for you. I'm glad you're on vacation. I was a little bit worried when you didn't hold the podcast last week, because I'm glad you're okay.
Well,
I see
that was
now.
because I was flying to, I don't know where I was, someplace. We're going in Spain. Don't even ask me these places. But we
Okay.
had to fly
Well,
into Frankfurt first,
oh,
and then we had to fly back into Spain. So I couldn't do the Zoom, but I did pre-record the opening topic. So.
all right. So I did you know, sending you some well wishes. So 'cause I was hoping everything was okay with you, because that's so unlike you. So anyway, just a concerned podcaster here. But anyway, my question today is, so I have a vacant unit that I'm trying to rent. It's in the city of Inglewood, and I accepted, the rental application forms, let's say from family A, and then about a week later, I accepted forms from family B, and now family A is kind of not producing all of the documents and the requirements that we had talked about. So how do I handle that? Because we can only run one credit at a time. I haven't run either credit yet. So is there
Well,
a
I
way,
mean,
do I have to go through with
well, if you
family
haven't run
A?
the first tenant's credit, then run the
No.
second tenant's credit, and And then, of course, if you took an application fee from tenant number one, you'll just give it back to him if tenant number two is accepted.
Okay, sounds good. Thank you.
All right. Thank you very much. Pamela Rich of Los Angeles, how are you? Pamela
Condo,
Rich.
all right. Hello, hello, hello. Condo owner in Venice. We have a tenant. We have an actual lease until September 15th. We do not want to renew it. It's just going to be over. Do we have to give notice in writing that we don't have that intention, or do we not have to do anything because it's the end of a lease?
Okay, well, first of all, this is in Los Angeles,
Yes, in Venice.
and this is an apartment.
No, it's a condominium.
Okay, and the tenant has, this is a 1-year lease?
It was 6 months, and we extended the lease, not month to month. We extended it for another 6 months, which brings it to September
Okay,
15th.
so under the JCO ordinance for the city of Los Angeles, the Just Cause ordinance, that tenant can remain in your condo until your grandchildren have grandchildren.
Excuse me?
There's-
What do you mean?
They're protected tenants. You have to have a reason to evict. So the fact that the lease
When a
is over,
lease-
the fact that the lease is over means nothing. They get to stay there for life until they do something wrong. Welcome to the world of owning property in the city of Los Angeles.
So, okay, so even though you have a lease for a year and we don't accept the 13th month lease, that 13th month. What?
Well, and
so-
that's right. Even though you don't accept the 13th month, they get to stay there. Let's go back over this again until your grandchildren have grandchildren. Because unless they do something wrong, that's not a basis of evicting. You have 12 reasons to evict for JCO properties, and the fact that the lease is over is not. Now, for JCO properties, if you're renting for on a month to month and they're less than 6 months, then you can serve them with a 30-day notice, get the hell off my property. But until that, you have to have a ground to evict. But let me ask you this question. Why do you want them to move?
Well, the real reason why we want them to move is because we're not sure what our plan is to do with the condominium. And so there's a high probability that we may want to go ahead and sell it.
Right. And the fact that you want to sell the property is not a ground to evict. So what you can do is you can wait till that would be November 1st when the state of emergency is over, and then you can raise the rent. And that might have the effect of getting rid of this friend. But other
Well, I
than
can
that,
still rent now, just no more than 10%.
you just have to understand that in our state, we have a total abrogation of all property rights. So the fact that your name's on the deed, that you pay the mortgage payment, you pay your property taxes, you do the maintenance, you own really nothing because the state is telling you what you can do with your tenants because these tenants need so much protection. However, the only thing you have is the fact that you can raise the rent because it is a condominium.
So the other wine would have been if we did it within the first 6 months, then we would have been okay.
And assuming you didn't have a 6-month lease, you'd have to have a month-to-month lease, and then in month 4 serve a 30-day notice.
Yeah. All right. All right. Listen, I learned something
Okay.
today.
Moving on to, and by the way, you guys try to do a show when you're floating on a boat with limited internet broadband service here. So it's been a little bit of a challenge. But I do got my triple monitors. You can't see that, but I do have my triple monitors up, and I've got lighting, and I'm doing the best I can. Anyway, Sam, how are you? And let's unmute yourself.
Hi, Dennis. How are you? Hope you're having a good trip. Question: do you have forms on your website for a single family homeowner who wants to rent one room to a boarder, somebody rents a renter room? You know, it's a little bit different than a typical apartment situation where they.
Well, it is different because you are living there yourself, but the rental agreement I have would work for that situation. You might want to add to it, there's a place to add addendum where you could add some specific language like you have to clean up the kitchen because you're sharing the same place, or this
Yeah.
bathroom is off limits to you, you only get this bathroom. But that rental agreement would work if you're renting out a room in your house, for example.
Okay. Any addenda that you suggest go with it on your website that would go
No,
with
that would
it?
really be specific. Just do a separate page. There's a box that says addendum attached, and just call it addendum and write whatever terms you want. Like you
Okay.
can't leave your
Thank you.
underwear in the living room.
Yeah.
Like pick
Yeah.
up after yourself.
All right. Thank you, Dennis.
All right. You know what? I am going to go out of order here right now. And let me go here. I'm going to go back and let's see if Eric Chavez, did I make it? Mr.
Yeah,
Eric.
you got it, Dennis.
Hey,
Hey,
how are you,
Dennis.
sir?
Okay, so my question, I own and manage a lot of property under the RSO, and we use your lease agreements, and we've been using your services for 15 years. Now, when it comes to bed bugs, can you come up with, update the addendum to make it more ironclad? Because I'm at a $4 million bed bug lawsuit. I reached out to the office, we turned over to the insurance, we're headed towards mediation, but now get this. We're potentially going to get hit that we're negligent because our protocol, and when we get a unit rent ready, we do the paint, do whatever upgrades, and as a precaution, we treat it for pests. They're saying because we treat it for pests that they're saying that there was bed bugs before. You know that?
Well, yeah, but I mean, they could say whatever they want. The issue is that they have to be able to prove it. So the fact that you, as your business model, treat it for pests only shows what a laudable landlord you are. Now, I know in my rental agreements that I have on the website, I do have a bed bug addendum, which technically you're supposed to give to that tenant. But again, I mean, you could make up anything that you want, but in law, you have to actually prove it. You just can't say it, and they would have no way of knowing that. So, but hopefully you got a big bad insurance policy that's taking care of this.
Well, we are, but I mean, like I said, we used your addendum and all that stuff, but now they're implying that we're going to pay up something on our end. I just the insurance can cover 100%.
Yeah, this is what's going on now. These lawsuits are being filed by these marauding attorneys, and they are just looking for a payday. And unfortunately, the insurance companies are just uh, paying out on them. So
Well, it
it's
sounds
just
to me
sad.
they're only going to pay out so much, and then they're going to pin it on us to pay something because they're saying that we're negligent because we knew there was bed bugs because that's why we treated the
Well,
unit
then you
before
might
we
want to
go
have
into the
another
system.
attorney look at that because if you're negligent, that's what insurance companies do. They pay when you're negligent, like you weren't watching and you ran into a car. That's negligence. So they can't use the fact that you're negligent to say that I'm not going to cover you. So, but again, you need to have another attorney check on that. We are going to move on because we're getting close to the end here, and we're going to move on to Zena. How are you?
I'm fine, Dennis. How are you? Hello,
I am
everyone.
good.
Okay, I have a question regarding a tenant that's a nuisance, and I just want to confirm that they should be served with a 3-day notice either to comply or quit versus a 3-day notice to cure. Is there a
Okay, well,
difference?
when you're dealing with nuisance behavior, okay, it's always going to be a 3-day notice to quit. For example, nuisance behavior, I think everybody would agree that if you took a gun and you shot it up in the courtyard, okay, that would certainly be nuisance behavior. But you're not going to serve them a 3-day notice. Hey, I'm giving you 3 days not to shoot up the courtyard again. So if it's nuisance behavior, that's always going to be a 3-day notice to quit. But if you have something else like, for example, unauthorized persons or a dog, or they've changed the locks to the unit, that's going to be a notice to perform or quit where you're giving them 3 days to comply.
So if they're doing both of those things, do I have
You
to
have to
serve
pick
two
one or
different
the other.
documents?
You have to pick
Okay.
one or the other. So you're either going to go for the nuisance behavior, and if it truly is nuisance, like, they're just making everybody miserable, and you've got other tenants who are going to come to court to testify, I would go with that one. But if you've got tenants that are reticent, look, the guy's making my life miserable, he's keeping me up at night, but I'm never going to go to court with you because I don't want to get my car keyed, then you might want to go on some other violation of the contract.
Okay. All right. Thank you. Have a
All right.
great
Well, you know what,
trip.
ladies and gentlemen? I think that I'm going to call it a day right now. I want to appreciate everybody coming out. I'm glad I had enough bandwidth to get through this. We will be picking this up next Saturday at 3 p.m. because if you can see me right now, you can see that I'm pretty tired because it's about 1 o'clock in the morning for me right now. So anyway, everybody have a great weekend and take care.